Hello, thanks for joining us on your channel of choice at this time, African Independent Television AIT. Welcome to Focus Nigeria, your program in which we put the searchlight on topical issues in the polity. My name is Benga Aruleba. It's my pleasure to be here this morning. A Federal High Court judgment in Abuja on Wednesday in the disputed Anambra Central Senatorial District seat may have put in complete disarray INEC's plans to hold a court-ordered rerun on January 13, 2018. Justice John Soho, who delivered judgment in a pre-election case instituted by Dr. Obiora Okonkwo of the People's Democratic Party, PDP, upheld the claims by the businessman that he and not Uche Ekunife was the validly nominated candidate of the PDP. The judge held that this being so, and relying on existing binding orders of superior courts, the PDP is the presumed winner of the election. And once the issue of the lawful candidate of the party had been resolved in favor of the plaintiff, then the plaintiff, Obiora Okonkwo, is the senator-elect and should be issued a fresh certificate of return.
Especially, the Federal High Court has just ordered that Dr. Obiora be sworn in as the senator representing Anambra Central Senatorial District, and that he should be accorded all the privileges of a senator. So, whether or not there was an order that there should be a rerun in January 2018, that doesn't count at all. That issue came up, and Justice Era Mohammed dealt with it. There was no appeal against that. And also today, when we were arguing, all the parties, including INEC, conceded, submitted to judgment. So it was on that basis that the learned judge of the Federal High Court, Justice Soho, granted our reliefs.
I thank the judiciary. I've always said that justice might be delayed, but surely not to be denied. In this particular case, I guess there is no more opponent, because it's like everybody has seen the reality on the ground and decided to show some understanding and concede to judgment. So everybody in this case is a partner in progress.
As I said, real fresh controversy here. What becomes of the previous views already expressed by superior courts on this case? Didn't, for instance, a court of appeal in one of the numerous cases hold that it was not a question of who was the PDP lawful candidate, but that the party did not hold a party primary known to law in the first place? And again, what becomes of the fate of Victor Ume here? He was not a party in this case. That has just been decided. All right, really testing the law to the very limit of its fabrics. And of course, like I said, is a fresh controversy that has begun here on the Anambra Central Senatorial District seat. And from the courts, let's quickly get to the National Assembly, where a public hearing organized by the House of Representatives on the controversial non-governmental organizations regulatory commission bill turned out to be the burial ceremony for the bill. Preponderance of public opinion, from those of civil society to that of faith-based organizations, went so horribly against the proposed bill.
People say if there is no crack on the wall, lizard cannot enter. Nobody will be going after you if there are no small bad eggs. It could be one or two. You understand me? It could be one or two. We must find a way, to see how we can self-regulate and look at how to cleanse the house so that no matter how small they are, we don't give them the opportunity. We want to assure you that we take your contributions, are going to properly dissect them and make recommendations. So
human rights organizations are particularly very worried about this bill because we know the consequences of it. You may or may not comply with the contents of the bill, but certainly you risk being found culpable under the law by any circumstance of interpretation of it. So when we look at the bill and when we look at existing laws, when we look at the Corporate Affairs Commission, when we look at all of the regulatory environment that guides the operations of CSOs in Nigeria, we know that there are adequate laws in the country today to guide the operations of civil society organizations.
So this commission, this new bill that they're trying to bring forward is going against the CAC. Having been registered with CAC is telling you you have to register again. It then begins to make you to renew your registration. It then begins to tell you you have to operate in certain areas, and then it has the power not to renew your registration without any reasons. And so, if for any reason faith-based organizations, you know, there's a statement or something that is said, they just refuse to renew you. And then the next thing is Section 21 gives them the power to sell off all assets belonging to faith-based organizations. Where is freedom of speech? Where is freedom of worship?
I think that even for me as a priest, if I fall foul of the law, treat me as a thief, not as a bishop. So I think that we should focus more on how to generate and sustain the energies of our people, as opposed to creating a situation in which we might find that the lines of suspicion are deepened. So much as I appreciate this conversation, I do hope and I do pray that the National Assembly will take very seriously the sentiments and the very well-reasoned arguments that have already been expressed by the various platforms that have responded to this bill.
I love that statement there by Bishop Kukah. If I run foul of the law, take me as a citizen and a Nigerian, not as a bishop. I'm going to come back to that statement when we start our discussions. If a judge, for instance, commits a crime, should he be related with as a judge or as a citizen? Okay, lastly in our review, the PDP Reconciliatory Committee continued its firefighting assignment on Wednesday in Abuja. The Governor Seriake Dixon-led Reconciliatory Committee met with one of the candidates who contested for the office of National Chairman in the just concluded National Delegates Convention, media magnate Raymond Aleogu-Dokpesi, who, though expressed reservations on how the process of the election went, he, however, said, as a true party man, he is committed to the larger interest of repositioning the PDP for the future.
Because we know the efforts you made going around this country, propagating the values and ideals of our party, using the mediums at your disposal. And you have always used those mediums to support the cause of the party, the cause of nation building also. Now, the convention came and went the way it did. As party leaders, we know that even though it was a family contest, yet we felt there was need to reach out to key leaders of the party, people who have been playing key roles in the party, and whose contributions moving forward will continue to be critical. We thought we should interact with you, to share ideas with you, to discuss some of the concerns or the issues that arose, that have arisen since after the convention, primarily not with a view to looking back as much as we would like all of us to focus on the future.
I believe that Nigerians will recall that I said that the convention and the election we are going into was not a matter of life and death for me. That I did state that I was conscious of the fact that power comes from God, and whoever emerges, I will give my unconditional support to ensure that this party is able to fulfill its mission, to ensure that the challenges that are ahead can be overcome much more easily. I had defining moments where I will have, on that Saturday, made one or two statements that would have totally damaged the convention. But that is not my mission. My mission is to ensure that this present APC government is removed out of office.
Now let's set the tone for our discussions. Now on Monday, a three-man panel of Court of Appeal justices sitting in Lagos dismissed the charges of corruption preferred in the name of the federal government of Nigeria by the EFCC against a judge, a serving judge of the High Court, Justice Ajiya Nganjiwa. The EFCC had accused the judge of collecting a bribe of $260,000 and 8.5 million naira in the course of his official assignment as a serving judge in Bayelsa. The judge had moments after his arraignment before the Lagos High Court raised a preliminary objection, but the trial judge, Justice Akitoye of the Lagos High Court, dismissed the objections and held that the charges filed against him were proper. But on Monday, the Court of Appeal ruled differently. Justice Osaruge Obaseki Adejumo, who delivered the lead judgment of the appellate court, held that the EFCC has no powers to arrest and prosecute a serving judge. The Court of Appeal said only the NJC has the powers to force sanction a judge for whatever misconduct, and it is only when such judges have been sanctioned, either dismissed or suspended, that any agency could then prosecute. The judgment of the Court of Appeal has sparked off immediate controversy, while some lawyers hail it and say it would restore the sanctity and the independence of the judiciary. Some others have described the judgment as a misconception of the roles and powers of the NJC, in that the NJC is just attempting to cloak judicial officers with immunity here. We are picking up the arguments this morning as we put this judgment in a different context of what it will bring to the anti-corruption war of the government. That's our discussion shortly, so join us after this short time. If you're just joining us, a very warm welcome to you. We're starting the discussions now, and of course, I already told you what we're looking at. The Court of Appeal on Monday, in a judgment in the appeal filed by Justice Ajiya Nganjiwa, who is being prosecuted by the EFCC for receiving a bribe of $260,000 and another sum of 8.5 million naira. Got judgment at the Court of Appeal to the effect that the EFCC was wrong in charging him to court and seeking to prosecute him when the NJC was yet to dismiss him. And that judgment has sparked off an immediate controversy. Lawyers are divided on this issue. Some are saying that this judgment is seeking to cloak judges and judicial officers in immunity. We'll be picking up the pieces of the arguments now. I'm joined this morning by Barrister Daniel Bwala. He's a member of Lincoln's Inn, London. Good to see you, sir.
Thank you. My pleasure, as always.
I like the cap.
Thank you. Resource control.
This one? Are you sure? Anyway, good to see you anyway.
Thank you.
But Silas Joseph Onu is also joining us. He's an Abuja-based legal practitioner, immediate past public secretary, Nigerian Bar Association, Unity branch. That's the Abuja branch of the bar. Good to see you, sir.
Good morning, Benga.
Yes. It's easy to know where this argument about whether the judgment of the Court of Appeal is seeking to give immunity to judicial officers. I also saw traces of that in the issues as formulated by the parties.
Right.
And I don't know, I'm not a judge. Probably the learned justices also, I wouldn't want to say fell into the error of following along with them by looking at the issues for consideration from the prism of the functions of the NJC.
Right.
And not whether a judge has committed crime and is being prosecuted.
Right.
First of all, this judgment is not an attempt to cloak judges with judicial with any form of immunity at all, is it?
Right. Thank you for having me. First of all, the judgment of a court is valid until it is overturned.
That's correct.
And then secondly, we appreciate the industry of the judges to arrive at the decision where they arrive. However, I have opinion that this decision may be classified as a judicial legislation because the decision of the court, in my opinion, attempts to, by way of judgment, make a law that for now is not supported by any statute, constitution, or even decided cases. For example, the judges have immunity from civil liability. You cannot sue a judge, for example, for delivering a judgment or saying something while he's proceeding with his trial. That is given and everyone knows. And I don't even think...
Is it a law or a doctrine?
No, it's the law. Okay. And then I don't think also that the judges are saying that the decision is saying that the judges cannot be prosecuted. That is not the issue. They agree that the judge can be prosecuted by law enforcement agencies. The crux of the matter is that they say the condition precedent for prosecuting a judge pursuant to the Constitution and some of the embellishment that you find in the Constitution has not been followed. And to that effect, the court is saying that the condition precedent for prosecuting a judge for a crime is first to allow the National Judicial Council to try that judge. With the greatest
is that supported by any law?
No.
Either the Constitution or anything?
It is not. There is no case law in Nigeria at the moment that states that the condition precedent, for example, if you are seeking injunction, interlocutory injunction, there is a condition you must fulfill. Yes. There are decided cases of the Supreme Court to the effect that if the conditions are not followed, you cannot get what you are seeking for. All right? If you want to prove the element of a crime and you want to convict someone, the law says you must prove the element of the crime, each of the elements beyond reasonable doubt. There is no law that states whether decision of the Supreme Court or a statute or constitution that states that the condition precedent for trying a judge for criminal offense is determining, having the NJC to determine first. And allow me to explain further. Those who make reference to the provision of the Constitution that vest powers on the National Judicial Council to administratively deal with judges fail to look at it that even within the context of the provision of the Constitution, it's not just NJC that is there as a body. Yeah. National Population Commission and the rest are there.
Civil Service Commission.
And the control and discipline that is referenced there are administrative control and discipline. When it comes to commission of a crime and prosecution of a crime, our criminal justice system establishes that it is the law enforcement agencies that can prosecute. But why are we even, to be honest, crying more than the bereaved? Because the National Judicial Council was informed by EFCC about the conduct of the judges and that they are going to be prosecuted or something like that. And the National Judicial Council sat in a meeting where they resolved that the judges should not sit further until the conclusion of the case. So why are you making a case for NJC that has already taken a position? That is point number one. And then point number two, there is a distinction between misconduct and criminal offense within the premise of the powers of the National Judicial Council. Because no matter how National Judicial Council sit over a matter relating to a judge, they cannot, for example, convict a judge. They cannot, for example, try the criminal offense in the conduct of their hearing. And as a matter of fact, I stand to be corrected, even in the procedure of the Judicial Council with reference to discipline of a judge, elements that are to be established are not to be established beyond reasonable doubt. So in essence, I'm saying that the National Judicial Council does not have criminal jurisdiction over the judges. If it does not have, and it is the state that has criminal jurisdiction, why should the state wait until administrative procedures are conducted regarding a judge? Because the administrative procedure is with respect to the clothes he's wearing, the judge, to determine whether the conduct of that judge is consistent with his code of office.
Okay, all right. You have opened so many flanks. We'll probably come back to them and pick them one by one. Because when you made reference to the AJC, I quickly chipped in that there's also the Federal Judicial Service Commission.
Correct.
Which is also in the same constitution in fact, next to the provision that their lordships cited.
Right.
And I'm going to be referring to the one related to the NJC and the Federal Judicial Service Commission. But Onu, while we were on the NGO regulatory bill,
yes,
Bishop Kuka made one statement that struck me immediately. He said, if I run foul of the law, deal with me as a Nigerian, not as a bishop.
yeah,
If a judge in Nigeria runs foul of the law, should he be dealt with as a judge or as a citizen?
well, it is simple. We are all equal in the eyes of the law. There is no super Nigerian, there is no super citizen. Whether you're the president of the Federal Republic, governor, senate president, senator, member, House of Representatives, or judge, the only person or persons that have immunity for criminal prosecutions are the president and his vice, governor and their deputies. And that is not even an everlasting immunity. It's just for the period that they are in office. Once they leave, you can still prosecute them. So a judge doesn't have immunity. If he does, we would have seen it clearly mentioned in the Constitution. Now, this case is very interesting because a very senior lawyer handled it. If I were the one who handled
Chief Robert Clark.
Good. If I was the one who handled it, or Boala, you would have started hearing issues of indiscipline, unethical conduct. Why will you argue such thing in court? That is, you know. Now, he started this case in the High Court of Lagos State, and the judge agreed with the EFCC that this is a criminal trial, and they do not need to wait for NJC to hear and determine and dismiss the judge. Because they say the NJC must dismiss the judge before criminal prosecution can commence against him, in order not to embarrass the office of the judge. By taking bribe, if it is reasonably established, you have already embarrassed that office. Once you are on trial, you're supposed to be interdicted. Once you're on trial, NJC is supposed to suspend you pending, which they did. That's interdiction. You step aside from functioning until the outcome of this trial. If you clear yourself, you come back. If you don't, from there we'll just dismiss you completely. Right? Now we go to the section the lawyer argued in court.
Yes.
That is Robert Clark, section 158
of the Constitution.
Let me read it for you, which Daniel tried to even embellish here very clearly. He said, in exercising his powers to make appointments or to exercise disciplinary control over persons, the Code of Conduct Bureau, National Judicial Council, Federal Civil Service Commission, the Federal Judicial Service Commission, the Revenue Mobilization and Fiscal Commission, the Federal Character Commission, and the Independent National Electoral Commission shall not be subject to the direction or control of any other authority or persons. Simply put, they're talking about the independence of these bodies as regarding their administration. Nobody should tell NJC which judge to pardon and which one not to pardon, or which judge to put on trial, or which judge not to put on trial,
which judge
to recommend, or which judge not to recommend. That is what they are talking about. But if you now take it to a ridiculous level of saying that if a judge commits a crime, NJC must first hear and dismiss him before the EFCC can try him because of Section 158, then I can also say it will be right that if a civil service is caught in corruption matters, the Federal Civil Service Commission must hear and dismiss him before the EFCC can try him, because they are all contained in the same section. So what makes the judge different? What makes the civil servant different?
There's an addition to that provision.
Yeah, which takes us to Section 153
of the third schedule.
Yes, of the third schedule.
Yes.
That talks about the functions and powers of NJC.
Yes.
Which basically is to
because I think that actually was one that the judge or the justices laid more emphasis on.
Yes.
That's 21.
Yes.
National Judicial Council. That's
Section 20.
Paragraph 20.
Yeah, of the first schedule.
Yes.
First schedule.
Yes.
Part 1.
Yes.
Now, which talks about the powers of NJC.
Yes.
Right?
Yes.
Now, if you look at the powers of NJC, you will see that basically their job is to recommend for appointment and promotion and removal of a judge.
Yes.
Now, if you want to recommend for the removal of a judge, it means that you must have gotten good reasons to do so.
Yeah.
You must have heard the judge because of doctrine of fair hearing. There must be a petition against the judge for misconduct.
Yes.
And it is issue of discipline, disciplinary control.
Yeah,
That
I
is
think
the
they made reference to
Yes,
B.
B said,
Recommend to the president the removal from office of the judicial officer specified in subparagraph.
Paragraph A of this paragraph,
Yeah.
and to exercise disciplinary control over
Over
such
such officers.
Now, disciplinary control does not mean criminal jurisdiction, like Daniel said. Disciplinary control goes to the extent of your official performance as a judge. Your official duty, whether you sit early or not, whether you hear your case within the period specified for it or not.
And I quickly link that because both Judicial Service and NJC
Yes.
and the Federal Civil
Judicial-
Service Commission
Yes.
were executive bodies created by
158.
Section 158.
Particularly Section 153, in fact.
Yes.
Section 153
Now,
established
if you go
all
back,
of
if you
these
go back
bodies.
to the provision under the same third schedule related to the Federal Civil Service Commission,
Yes.
has the same function,
Yes.
the same word for word as you
Yes.
have for the Judicial Service Commission
Yes.
for the NJC,
So it means-
which is to dismiss and exercise disciplinary control over persons holding such offices. In other words, civil servants.
Yes. So it therefore follows from this judgment that the police cannot arrest and try a civil servant who steals from public funds until the Federal Civil Service Commission
Yeah, if you
disciplines him
stretch the
and
same argument.
disciplines him and dismiss him. Because judges don't have two heads. They work for us, right? They are supposed to be above board. That is why they have all of these rules. In fact, that a judge is even suspected of taking bribe is bad enough, right? It's bad enough because he is supposed to be an example of integrity, an example of forthrightness. Now, this man is not denying that your charges against me are unfounded. What he said was that you should first of all send me to NJC. Let them hear and dismiss me first. Before you will now begin to try me, because I'm a judge. I'm a holy man. A judge is holy. Therefore, you can't take him to the dock to try him. So what I'm saying basically is that this judgment is a slap on the face of the judiciary and the Nigerian nation. As far as I am concerned, Nigerians deserve an apology from those justices. That is my view. They deserve an apology from them.
Mr. Boala, let's look at it from the context of the powers of the NJC, powers of disciplinary and control that the Constitution donated to the NJC. What does it mean? You see, when the NJC exercises powers of discipline and control over judicial officers,
right?
What does it
now,
mean?
I will speak to the two concepts.
And when you talk of the judicial functions of a judicial officer,
yes,
what does it mean?
Well, the judicial officer performs the function under Section 6 of the Constitution. It's clear about the powers of the judiciary. Then powers over disciplinary steps against a judicial officer is determining whether or not the judicial officer's conduct is consistent with his code of office. And the code of office is express and clear. So when they sit, what they determine is that misconduct complained about, whether ranking it pari passu, what is expected of him as he took the oath of office, it is consistent. Now, it is also possible that a petition can be written for which crime will be inferred, that he collected bribe or he even shot somebody. It's possible. And this crime contained in the petition may also form part of the misconduct. But the judges who sit as members of the disciplinary committee, remember, they are sitting and live judges. They have jurisdiction when they sit in their respective courts to try criminal matter. But they are not oblivious of the fact that when they sit as a council, they do not have criminal jurisdiction. Now, coming to
they are not operating as judges.
They are not
administrative body.
No, they operate as judge because they take evidence. Yes, they take evidence.
Yeah.
But they
For
have
administrative
limitation.
purposes.
For administrative purposes. They have limitation. So that is why the evidence of acquittal of a criminal proceedings cannot be a ground for acquittal in criminal trial. And if, like in the case of Justice Ademola, he was discharged and acquitted, he can still be discharged and acquitted, and NJC will still find him guilty So each, whether in the court or the National Judicial Council, the evidence of acquittal or conviction cannot be a ground to be used. Unlike in a malicious prosecution, where the minute you get acquitted by the court, you can use that to then sue for compensation. So if that one is clear, the issue of control comes. And this is where, in my opinion, I have always advocated for friendliness and collaborations in all the agencies and government organs. Now, this is where communication between the law of enforcement agencies and the NJC is pivotal. The reason is because that word control you see there,
yes,
it means the National Judicial Council can decide to tell a judge, please do not sit like they did in this case until the case is concluded. Now, why it is necessary, not law, but why it is necessary for law enforcement agencies to notify NJC of a criminal allegation against a judge as they proceed. I won't say before they proceed, I will say as they proceed. So that the NJC, in the exercise of their powers in the Constitution for control over the judge, will order the judge not to sit until the case is concluded. Because if you do not notify NJC, it means they are not in the position to know the allegation against him. That means he can be in the dock today and be in the bench tomorrow. So that is why the communication is necessary. Okay. But to say that it is a condition precedent, this is a new law. So except if the Supreme Court holds the opinion of the Court of Appeal, then it has created a new gamut of law in our corpus juris, because as it stands now, there is no specific law that says the condition precedent for criminal prosecution of a serving judge. And I'll give you instances of countries. If you go to America, different states have their own different rules. In California, they have Commission of Judicial Performance. And the way they operate in California is, if a petition is written against a judge, even if there is a crime, there is that understanding that that will be dealt with by that committee before the federal or the state can prosecute that judge. If you go to Wisconsin, they have their own modus. They have, in fact, they call it Board of Judicial Discipline or something like that. In Wisconsin, a case involving a judge came up. He was prosecuted first before the board had to sit. If you go to England, they have also their own board that discipline the judges. Somewhere in Liverpool also, a judge connived with solicitors and they committed a crime. The law enforcement agencies studied them. By the time they sprung into action, at that point and at that time, there was no determination by the board or by the commission or by the office that was supposed to discipline the judges. So depending on the case, a judge also, I can't remember which of the states in England, allowed her Rottweiler to bite somebody, and she was straightforward prosecuted before that, before she can be referred again to be disciplined. So there are instances where the board or the commission or the committee or the council sits over the matter. I will give it this way. If a petition had been written and the council had already started sitting in respect of a matter involving a judge, as a spirit, in the spirit of esprit de corps, it will be necessary at the point for the law enforcement agencies to wait until this matter is determined, and then they will proceed. Where there is no commencement and ongoing proceedings in respect of a judge, and in most cases the prosecution would have noticed that even before petition can come to the judges. I do not think that the law, because look at the implication. If EFCC conducts an investigation, come up with heavy evidence against a judge, writes a petition to NJC stating some of the evidence, and they have to wait until agency determine the matter. And while the agency is determining, remember they are not sitting till they determine it in one day.
Exactly.
There are adjournments and things like that. If the state will have to wait until that is concluded before they will take a step, the chances are that the evidence may be destroyed, investigation may be interfered, and I don't know, in that judgment, it was reported on social media that they used the word cannot be investigated or prosecuted. Now, if the way it is couched, that is the way it is in the judgment, then I would say that it is unfortunate. The reason is because even when you write a petition as a law enforcement agency, it's as a result of your investigation. That means if you cannot investigate before you write a petition, then that means what you are bringing is frivolous. There has to be an investigation, and then when you have a concrete allegation against the person, before you can report. So my understanding of the law is that there is no criminal jurisdiction with the National Judicial Council, and that National Judicial Council cannot, in my opinion, as a condition precedent determine criminal law before the law enforcement agencies will
Let me read this tweet, and it's going to take the form of the next question. And the tweet is coming from Samuel C. Chuku. It says, it appears that there is a misconception here, SARS. Once a judge is put on the stand, whether he is guilty or not, he has lost public respect. What happens if he is innocent? The arguments and examples by my learned colleagues already assume the guilt of these judges.
Well, Justice Ademola went through trial, and he returned to his court and continued with proceedings. If you get acquittal, it means nothing was against you.
Strengthen your integrity.
It strengthens your integrity. In fact,
is the NJC equipped to engage in forensic investigation that is required in the establishment of commission of crime?
Now, let me tell you something now. Let's just draw a
because their lordships also made reference to the NJC rules and code.
Let me just draw a simple distinction here between misconduct and crime. For a judge, if a judge comes to your program now to discuss how he operates in his court,
that's misconduct.
That's misconduct, but it's not a crime. Right?
And the EFCC will not arrest him outside
NJC
of it.
can discipline him for doing so. If a judge is seen in a birthday party, drunk and dancing anyhow, that's a misconduct, but it's not a crime for him to drink and dance, right? But if a judge is caught taking bribe, that is a crime, and it's a misconduct, isn't it? Now, misconduct goes to the integrity of the judiciary as an entity. It's not an offense against the state. But a crime is an offense against the state, which supersedes the judiciary as an entity. So you cannot say that when a judge who is representing an arm of government commits an offense against the state, he should be given a special treatment. No. If it's a crime and there are evidence to proceed against him with, they should go ahead. If at the end of the day, he is acquitted like Justice Ademola, he goes back to work. If you feel that he cannot, he can resign on his own. Nobody will force you to continue as a judge. But you see, a situation where, I will repeat it, where every arm of government, because some lawyers will tell you the judges are reacting like this because of the recent raids on judiciary, so they are fighting the executive. We can't take our responsibility and turn them into a battlefield, challenging the other arm of government, trying to show you we can frustrate your efforts. We can't succeed as a nation like that. The judiciary cannot begin to shield its own because the responsibility is theirs to determine crime and all that. No, they can't. Even if this judge is the younger brother of all the Court of Appeal justices and he's brought before them, and there is a clear crime committed, and EFCC say we have evidence, it is the function and duty of the court to say, let's hear your evidence. If at the end of the day, the evidence cannot succeed, you state so that your evidence cannot succeed, and this man, you have not linked him to this crime, so he can go free. But if at the end of the day, you prove his case, the EFCC proved their case, you should jail the man, and once he's found guilty, it will follow automatically that his act is now a misconduct. NJC will recommend his removal immediately. They don't need to now call him again to come and hear what he's saying. The moment we are lawyers here, if today any of us is involved in a criminal case and the police successfully convict, secure a conviction, it follows automatically that the legal practitioner disciplinary committee will just take the judgment.
Doesn't need to even call you.
They don't need to. They'll just take the judgment and disbar me automatically. But now what you're saying is that me too now I will start to use the rules of professional conduct to cover myself. Say if I commit crime, you must send me to NBA first, disciplinary committee. If they don't find me guilty, the police cannot prosecute me. This is ridiculous.
There's something very important here that we need to also discuss, Pastor Paula, which is the NJC rules of procedure. Right. The NJC has said over and over again that it can only investigate petitions written against judicial officers complaining of misconduct.
Yes.
The NJC on its own cannot initiate anything. Right. It only acts on petitions. Yes. In other words, if nobody writes petition against a serving judge, the NJC cannot move against a judge.
They have other
that
rules.
Is not the condition precedent to crime.
Right.
a law officer sees you committing a crime, he doesn't need to wait for any prompting.
No. Right.
He kicks in the law from there. He kicks in the process from there.
Very correct.
So these are two different processes that
what you have said further buttress the point we are making. Dividing distinct, try to divide the misconduct and then crime, and how that crime must be prosecuted by the state promptly. But you see, let me digress to say this. You see, we are when conversation like that comes up about judiciary and corruption in the judiciary, the impression people have as if the judiciary is sitting somewhere dormant and we are coming to fight, to fight corruption in the judiciary. Do you know that the judiciary is in the forefront of the fight against corruption? Do you know that the NJC have been suspending judges, putting judges on watch lists, dismissing judges, removing their clothes promptly when petition comes?
Even without petitions.
Even without. And do you also know that the Chief Justice of Nigeria set up a committee called Anti-Corruption Trial Monitoring Committee as a proactive step in fighting corruption? So I don't know where people are coming from outside to speak for NJC that is in the forefront of the fight, as if the NJC is not doing anything and somebody is coming to invade them. That is why I believe that this matter should be tested at the Supreme Court. Let's have a go at what the Supreme Court would view in the light of distinguishing between misconduct and crime. When a judge appears in the door, he's not there as a judge. If he has to be there as a judge, then it will be the state versus NJC or the state versus the judiciary. He is there as a defendant. That is the rule of law. In his personal capacity as a person.
For abusing his office.
For abusing his office.
The lead judgment of Justice, what's his name now? Where's the judgment? Sorry. Justice Obaseki, Osaruge Obaseki Adejumo.
Right.
Makes reference to 3 documents. This one, that's the National Judicial Discipline Regulations, right. The National Judicial Council revised NJC guidelines on procedural rules for the appointments and judicial officers and all superior courts, as well as the one on judicial policy, the National Judicial Policy. Right. The judgment made reference to it. I went to look for these 3 documents again. Right. This one is very apt. That's right. The Judicial Discipline Regulations. The NJC here says the time limit within which a complaint must be made. In other words, NJC acts only on complaints of misdemeanor and all of that against judicial officers. A complaint must be made within 6 months of the event or matter complained of, provided that a complaint relating to a continuing state of affairs may be made at any time while that state of affairs continues or within 6 months from where it ends.
Right.
Does this take on board the process for prosecuting crime?
Because
from arrest to prosecution.
Yes, because in criminal law, that's another point. Thank you even for adding. That's another point. In criminal law, there is no statute of limitation. You cannot say this is the time within which if a crime is not brought.
So if the judge collected the bribe last year, and you are just knowing now, this rule precludes you from complaining to the agency
about that. So you see, that's the argument. That is why we hold the view and strongly that it is administrative powers, control, and discipline that the NJC has over that judge. For example, they can't sentence a judge for a crime. They can't sentence a judge for any crime because sitting there as NJC, even though they are judges, they do not have that criminal jurisdiction. So it is clear now. Stretch the argument further. You just talked about time limit within which
there are so many of them. The next one to it is subject to Regulation 5. A complaint made outside the time limit set in paragraph 1, that's the one I just read now, must be dismissed. A complaint made outside of that time must be dismissed by the council upon report to the council by the secretary to the council.
You see, what law enforcement agencies cannot do, EFCC cannot arrest a judge for delivering a judgment that in their opinion is perverse. They cannot arrest a judge for giving a ruling outside of the period or judgment outside of the period required by him. They cannot arrest a judge because, like the way Onu said, he was dancing somewhere in a party. Or they cannot arrest a judge because he was somewhere shouting. Because these are matters of ethics contained in the code for
as judicial officer.
As a judicial officer.
It's just
not
like, as a citizen.
Just like in pastorate.
Yes.
If a pastor is seen in the public behaving in a manner that is unbecoming of a pastor, the church would discipline him only insofar as it relates to his conduct as a pastor. Yes. Once it is a crime, it is the state. That's why part of the conditions when you come to court, they look at jurisdiction of the court. For example, if you're looking at party, the state versus so and so. And you see, people are complaining that what we are now having is that every arm of government is trying to create a quasi-arm of the other government in there. So judiciary is trying, people are saying, trying to create legislative department by way of this kind of decisions, and also the executive arm. Then the National Assembly, they are looking at this thing. Let me even tell you something, Mr. Benga. If this decision is sustained, all the judges presently being tried will have a ground to have all of their charges quashed.
Yes.
Because there is no proceedings and conclusion by NJC on them.
And then it will also be unjust if you do that for judges, and then you leave the public officers whose misconducts are supposed to be tried by Code of Conduct Tribunal to be in courts. It means you move all the cases against politicians to Code of Conduct Tribunal.
Just to further buttress the point that the NJC has powers to deal with complaints only as it relates to official conduct of a judicial officer while performing his judicial function.
Yes.
I'm reading the rules further. Number 6 now is failure to comply with time limits.
Yes.
Where in the course of disciplinary proceedings, any person who fails to comply with the relevant time limit set by anyone empowered to so do, the person exercises the function to set time limit may, 1, he may continue to deal with the case. 2, treat representations made outside the time limit as if they have not been made.
Thank you.
In other words, no matter how valid or cogent the
complaint
is, like in this case, that a judge 2 years ago collected bribe, but because you didn't make the complaint within 6 months, you are making it now. As far as the agency is concerned, and as far as the rules of procedure for dealing with a judge is concerned, it never took place.
And these rules guide their proceedings.
There are laws that makes a crime limitless. The statute is not barred. A crime, there's no statute bar for a crime, right? If you commit a crime today and it takes the police or EFCC 50 years to investigate, if you're still alive, they'll prosecute you. If it takes them 10 years or 1 week, they'll prosecute you.
In some countries, they prosecute you even when you're dead.
Yes. Now, what we're saying here is simple. Which one comes first? Should we try misconduct before crime? Because misconduct is much more serious than crime, or should we try crime, which if we can address crime, we automatically address misconduct? This is the simple logic here. But there is no reason for that judgment outside the fact that these judges want to protect their own and even themselves, because they believe that I may be a victim of EFCC tomorrow. A judge is expected to discharge his job without fear or favor. Whether you are the victim, if the case is before you, you should do justice to it. Don't try to shield yourself because you are the victim. Try to give yourself some special room for escape. No.
But at this point, let me differ.
Somebody said I should ask you. Somebody said I should ask you. Leo says I should ask. Please ask Barrister Boala whether it's right or appropriate to dock a serving judge since our statute is devoid of any precedent. None of the judges that were charged to court were still serving. As at the time they were arrested, yes, the NJC said there were no complaints against them. But the moment they were arrested and they were detained, the NJC gave directive to all of them to stop sitting.
Yeah.
So we can say that none of them was sitting.
They were not suspended.
So none of them was sitting as at the time some of them were charged to court.
And secondly, there is no criminal jurisdiction. There is no criminal immunity for a judge. And I talked about earlier, so that we don't forget this one in closing, I talked about the need for collaboration. So that while the law enforcement agencies are prosecuting, if NJC is not aware, that's why you have to notify them, but not as a condition precedent. Because if they are not aware, they will not issue directive, because you read about control for them not to sit until the case is determined. But let me, in a final note, differ from what my friend, ONU is like an activist. When he said they are protecting themselves and then no. I see it as a judgment delivered based on the facts before them and in their belief of the law. You see, it's not every judgment that a judge gives, if we're right or wrong, that he does.
I think both the lawyer for the EFCC.
I don't paint black, white.
I think both the lawyer for the EFCC, Rotimi Jacobs, SAN, and Chief Robert Clark.
Yes.
Clark with an E. Yes. Both of them misled the justices in the way they couch the issues for determination. They shouldn't have narrowed it to whether it was about immunity for judges or not, because it's not about immunity for judges.
Nobody misled anybody.
It's about whether a judge, whether serving or retired, can be charged to court if he committed crime.
The ruling of the High Court of Lagos was clear for the Court of Appeal to see. Nobody misled anybody. The Court of Appeal is just trying to cover themselves by using a case that may relate to them tomorrow to shield themselves ahead of maybe possible police invasion that has happened. Now let me tell you what, because of this kind of conduct, you see what is happening in Justice Yunusa's case. Judges are just recusing themselves. They don't want to try the matter. So what do you now have a judge for? If they bring a case before you because the person was a judge, and you just say, no, I won't try him. So it means judges have become special super citizens that cannot be tried.
We have to go now.
It's a sad day for Nigeria.
And then Long John says the judges cannot arrogate to NJC the powers they do not have ab initio. No extant law substantiates this ruling. All right. Thank you. Let's leave it there. Barrister Daniel Bwala is a member Lincoln's Inn, London. Thank you so much. I appreciate your time.
Appreciate that.
And of course, Silas Joseph, on which inn are you?
He says he's activist, so activist inn.
Thank you so much, Barrister. I appreciate your time. That's Focus Nigeria today. Thank you for investing your time with us. I'll see you tomorrow. Enjoy the rest of the day.